Hello, everyone, and welcome to our webinar, Estate Planning Basics. My name is Beth, and I'm the Marketing Director at Pirro, Connor & Associates. I'm joined here today by attorney Lou Pirro, who I have the pleasure of introducing today right after a few brief announcements. As you can see, we are sharing our webcam, and to ensure a clean recording of today's 30-minute presentation, your lines are muted. Everyone should have a Webinar Jam control panel on the right-hand side of your screen. Later, we'll display some additional information there. If you have questions today, please email them to this address, info@pirrolaw.com. We will respond individually to those questions. Previously, we sent an email that included our 2018 estate planning guide. Following today, we'll be sending you the estate planning questionnaire that Lou will be discussing. And finally, we always ask for you to complete a survey when the webinar is complete. Let us know how we did by providing your feedback. A link for a free consultation will also be displayed at the end. Now it is my pleasure to introduce our presenter, Lou Pirro, the founder and principal of Pirro, Connor & Associates. He concentrates his law practice in the areas of estate planning, elder law, business and tax planning, and special needs planning. And we're very proud that Lou was recently honored as the 2018 Lawyer of the Year for Elder Law for the Capital Region. Thank you, Lou, for being here.
Thanks, Beth. Hello, everyone. Welcome to our inaugural webinar. We're grateful for you to join us. It's great to be here, and we're going to talk about a number of topics over this series of webinars as time goes on. We have our second webinar scheduled, as you'll hear about, for February 27th, and that's going to be on trust planning. So they will in some ways be building blocks, but they will also stand alone. And if you missed it or you have a friend that you think would benefit from any of the webinars, we will be posting them on our website, so you can see them there as well. So with that, let's get started. So estate planning basics is today's topic, and we're going to be talking about the four-legged stool of estate planning. But first, let's talk about what estate planning is and what your goals of estate planning should be. And as we go through life, we all face challenges. We face different time periods in life that bring crises, bring great times, but also bring things that challenge us from a legal, financial, and family perspective. So the real goal of estate planning is to be prepared. And people often ask, well, when should I do estate planning? What's the best time to begin this process? And not to be glib, but my answer is, well, tell me the day you're going to die, and I'll make an appointment for the day before, and we'll get it done. But nobody knows that. We don't have a crystal ball. We can't predict the future, but we can plan for the future and prepare a comprehensive estate plan that will take away the risks that our families will face and that we will face in the event that life happens. And when we do estate planning as attorneys, we play the what if game. What if I become disabled? What if I become incapacitated? What if I die prematurely? These are hard questions, and estate planning is not a topic to be taken lightly. But at the same time, it needs to be approached professionally, and you need to do it with a competent attorney to walk you through the process, as we're going to do today, to get the information that you need, and we're going to show you how today, and to put that information to work for you in documents that fulfill the needs that you have for a comprehensive estate plan. So just identifying goals. What is it that we're going to talk about in the next half hour? What do we want to accomplish through our estate plan? So appointing individuals to handle various tasks on our behalf, both during our lifetimes and at death. And a lot of people think that estate planning is simply planning for when I die. But in today's world, it is just as important to plan for when you live as it is to plan for when you die. And proper estate planning covers a situation where you have different needs. You become incapacitated, disabled, you're unable to carry out functions on a day-to-day basis. It's critical that we have the right people in place with the right powers, and that they can make decisions for you and to carry out functions, vital functions on your behalf when you are unable to do so. Upon death, you're going to also create a will, and we'll talk about that. and appoint people to carry out the estate and make sure that your estate is handled properly, go through the probate process, and we'll talk about the will and probate and what all that means, and to make sure that your beneficiaries, your spouse, your children, grandchildren, your other loved ones, make sure that they are taken care of in the way that you intend. So that's one goal of estate planning. We also want to make sure that there's something left to leave. So preserving assets, protecting assets, and making sure that we don't pay too much in taxes, that we don't get stuck in a vice where we need Medicaid but can't get it because we have not taken steps to protect our assets. So all of those things are also goals of estate planning, ensuring that you have protected and preserved assets through your estate plan. Providing a legacy and how to provide that legacy. How do we leave assets to the next generation, and what's the most effective way to provide money, assets to our children, our grandchildren, our spouses in ways that they can use them, but that at the same time, those assets are protected for them. And we'll talk about in our next session on the 27th, trust planning and the use of trusts in particular for yourself and your beneficiaries to protect and preserve assets, and to make a lot of this much more simple. Because with trust planning, although it's a little more work up front, as you're going to see, the benefits downstream are significant. And finally, we want to make sure that you ensure your standard of living. We don't want a plan that's going to have us run out of money before our time. So we want to make sure that we don't outlive our money, and make sure that the funds that we have and the assets that we have are going to be done in such a way and protected in such a way that we have full asset protection as part of our plan. So let's take a look at the next set of slides here. And this is getting into what I call the four-legged stool of estate planning. And the four-legged stool of estate planning is a will, power of attorney, a healthcare proxy, and a disposition of remains appointment. And these are the core four documents, and these address some of those goals that I mentioned earlier. So when we're alive, we want to make sure that we have the appropriate decision makers, the people that can make financial decisions, the people that can make healthcare decisions. And those two documents are the power of attorney and the healthcare proxy. And we'll get into more detail on how to construct those two documents in just a moment. Upon death, we want to make sure that we have our assets going to the proper individuals. We want to minimize taxes. We want to minimize costs and expenses, and have a plan that's going to integrate all of our assets and property into the right vehicles to go to our next generation. And part of what in New York we have is a fourth leg to the stool. Many states don't have this. So if you're watching this from another state, you really have to consult with state law on this last one. And that is a disposition of remains appointment. And that document came into play about 10 years ago, and we've been using it ever since. And what it does is it allows you to appoint an agent to make final arrangements, to carry out funeral and burial directions, to make sure that things are done according to your wishes. And a lot of people have done this in their will. But my experience over the last 34 years has been, if you have a burial direction in your will, it's not going to get looked at until after you're already buried or something has already been done with your remains, because the will typically isn't viewed prior to the funeral. It doesn't get pulled out and looked at right away in many instances. So New York came up with a legally binding document. It's in the statute and public health law, and you can now appoint agents to carry out final arrangements. And we'll talk about some of the considerations in that particular document when we get to the disposition of remains section, and I call that affectionately the DORA. So let's move on and talk about the power of attorney. Powers of attorney are vital documents, and over time, these documents have been used and in some cases misused. And so in New York State, there has been a vast amendment to the power of attorney law, and that happened back in 2009. So if you have a power of attorney that was done in New York prior to 2009, then you should be okay, but you may want to have it looked at because the new document, the new form, brought in many new features. And in the new power of attorney enacted in 2009, our firm, which had a very comprehensive 3-page power of attorney in 2008, suddenly had a 16-page power of attorney in 2009. And in the new document, you can do things like appoint monitors to oversee the agent. You can provide for compensation for the agent. You can modify the document and provide for all types of things like home health care and personal service contracts. And we modify our document substantially. But one of the biggest changes is if you want your power of attorney to carry with it the authority to do further planning on your behalf. So when we're doing estate planning and we enact a power of attorney, in many instances, we want the agent to have the authority to do further planning at a later date if I need to get Medicaid or I want to save taxes. And for that now, in the power of attorney document, you have to execute a statutory gifting rider. And the statutory gifting rider is an additional several pages that gives authority to your agent to do things like transfer assets, apply for Medicaid, create trusts on your behalf, make gifts for tax planning purposes. If you want your agent to have the authority to gift on your behalf more than $500 in any given year, then you must do the statutory gifting rider as part of the power of attorney. So who do you appoint? You appoint people that you trust, and you want to make sure that these are people that are going to look out for your best interest. Under the new document created in 2009, you have to do a gift, not just a gifting rider, but you also have to have the agent sign an affidavit saying that they're going to act in your best interest. And so that's also part of the new changes. And we're looking at the principal being you, the person appointing, and the agent being the person that is going to be serving on your behalf. So the screen you have in front of you now is part of our estate planning questionnaire. So we're tying the legal documents to the actual gathering of information that you will need to go forward and prepare a power of attorney. So you'll see here several questions as part of the questionnaire. And as Beth mentioned earlier, you'll be receiving the questionnaire via email. If you want to see it now, if you can't wait, you're one of those people that just can't wait, you can go to our website and you can download the questionnaire at pierolaw.com. But you'll get it in the email following today's webinar. And so the first thing you see there is a springing versus a general durable power of attorney. Springing power of attorney being a document in New York that you can create that is contingent upon the happening of some event in the future. Typically, we use a medical contingency if we're doing a springing power of attorney, so you can sign the power of attorney. And if you don't trust your agents sufficiently to have the power now, you can say that the power won't take effect until a physician determines that you are currently unable to manage your financial affairs. We don't do a lot of those. Number one, it's very difficult to get that physician affidavit to spring the power of attorney. And number two, by and large, if you don't trust the person enough to have the power now, you probably won't trust them enough to have it later. So we don't use the springing power, but it is available for people that want to hedge their bet, have the document done now, and then not have to have it effective immediately. We then appoint agents, and you'll see agent number 1, 2, and 3. And in a power of attorney, you can have single agents or co-agents. And you'll see there, you can have them act together or separately, so that if you name 3 people and you require that they act together or jointly, each one has to sign. If you have 2 people, both have to sign. If you want multiple people, very often 3 children, we don't want to discriminate, right, parents? And we'll name all 3, but we'll allow any one of the 3, and that's separately, to act on our behalf. So one of the themes you're going to hear in our office is put on as many alternate agents as you have. You never know. So we appoint primary agents, and then sometimes, again, in a power of attorney, co-agents, but we always want to have successor agents in the event that our primary agents, for whatever reason, are unavailable. We want to make sure that we have sufficient agents lined up. So there it is, document number 1, our first leg of the stool, the power of attorney. And next, we're going to talk about the healthcare proxy. And the healthcare proxy is the healthcare side of the power of attorney. So instead of making financial decisions, which an agent under a power of attorney does, your healthcare agent makes healthcare decisions. This document is very tried and true in New York. It's been in the law since 1993. It's a statutory document. We modify it substantially in our firm, and we use something called the living will language, and we put living will language and embed it right in the healthcare proxy. So you appoint an agent, and in this case, the law asks for a single agent. They don't want your agents to get to the hospital and conflict on what the proper course of treatment is. So they want you to choose one person at a time. We can always put in that you want them to consult with their siblings or other family members, but one single agent gets the authority. If they're not available, the next agent in line, and again, we want to appoint alternates, and we want to make sure that we're giving them specific instruction. So we have an agent and alternate agents, and we give them instruction on what our wishes are, in particular with regard to end-of-life decision-making. So if you don't want to be kept alive artificially by ventilators and other artificial means, you will put that in specific guidance in the healthcare proxy document. And we work with our clients to fashion and craft that language to meet their specific needs. There are other documents that people often confuse with the healthcare proxy. One is a DNR, or do not resuscitate order. A healthcare proxy is end-of-life decision-making when you are alive and being kept alive. A DNR means you have coded or died, and do you want to be brought back? So that's a very different document. And so when you're doing the healthcare proxy, you want to, again, go to the questionnaire and fill out page 8 of the estate planning questionnaire, appoint your agent, and again, single agent in each case. And then think of what your wishes are with regard to end-of-life decision-making. Do you want artificial nutrition and hydration? That's one element that if you want your agent to be able to remove, you have to put specifically in the document. So choose your agent, think of your instructions, and the healthcare proxy is the second leg of our estate planning stool. We're now on to the disposition of remains appointment. And this again is upon your death, who claims the body, who makes sure that the funeral arrangements are done according to your wishes, what are your wishes. This document in New York, and it's somewhat unique, again, not all states have this, but we like it and we've been using it for over 10 years, and clients have appreciated the fact that they can now put this in writing and make sure that their wishes are carried out. So you allow an agent, you put the agent in place, and you can limit the powers or you can give them very broad powers. So some of the considerations, and again, we'll go to your questionnaire. When you receive it, this is page 9 of the questionnaire. Just like the healthcare proxy, the disposition of remains appointment needs to have a single agent. Cannot have multiple agents on a disposition of remains because, again, they don't want them to conflict with regard to the end of life or afterlife decision making. So we sign the disposition of remains appointment, and we very often put instructions in, and you'll see considerations. Do you want to be cremated? And in my opinion, more people today want to be cremated than not. I don't think that was the case 30 or 40 years ago when I started practicing, but I think a lot of factors have come into play and more people want to be cremated. And believe me, we have people that have come up with creative ideas on where they want their ashes to be. We have clients that want destination funerals. They want their family to take the ashes to Ireland or Jamaica and to have a party and sprinkle them on the beach or in the fields. And it's something that you can do very personally. We have people that have agents that are instructed to divide their ashes and to distribute them if they have 3 children, as I do. Each of my children is going to get some of my ashes. They don't know that yet, but they're going to have an opportunity to have their own private ceremony and to distribute those ashes somewhere meaningful to them. So you can be creative here, but we want to get good, solid instructions. Have your agent who you know will carry them out. Appoint alternate agents, and that's a third leg of our stool, the disposition of remains appointment. So now on to the will, and this is what most of you are probably familiar with as far as estate planning, and it's what you think of when you think of estate planning. And the will is the document that's going to allow you to provide for the orderly, systematic, and secure disposition of your assets upon your death. And the assets will be distributed to those people you name in the will by an executor. So you're going to choose an executor, provide for the distribution of assets. If you have minor children, this is where you will appoint a guardian of those minor children. We will very often create trusts right within the will so that you have the opportunity to create something we call a testamentary trust. That may be for a spouse, that may be for tax purposes, it may be to protect assets for a child from divorce. All of those trusts can be embedded right in your will. And again, you'll designate the executor, the guardian, and the trustee. So when we go to our questionnaire, we're going to look at that, and we're going to look at the necessary fields to fill out. And you'll see here, maybe it's not too legible, but when you get your questionnaire following the webinar, you'll be able to read this and look at tangible personal property. Do you have jewelry? Do you have personal effects, things that you want to go to certain people? And if you do, that's going to be delineated in the will itself. In New York, we can't keep a separate list of assets and have that incorporated into the will. So if you have things written down on a piece of paper and you simply refer to that in your will in New York, that's not a legally binding document. Your executor may follow it, but they don't have to legally. And that's going to be something where you're going to want to make sure that if you're using a will, that you have the specific dispositions of personal assets, your jewelry, your heirlooms, your artwork, antiques, family paintings, those kinds of things you're going to want to do and have those specifically set out in the will. Your Maserati, everybody has one of those. And all of those kinds of things you're going to want to do here in the will. Then we get to what we call the residue or remainder of your estate, and that would be the assets, real estate, business interests, personal property, stocks, bonds, etc. Those types of assets go through the will and would go on to beneficiaries. Now, I have to talk here briefly about coordination, because having a will by itself doesn't ensure that your assets are going to go where they're supposed to go or be protected in the trusts under your will. It's absolutely essential that you track every one of your assets and look to see if there is a beneficiary designated on that asset or if ownership may be joint. Because if you have a beneficiary, for example, on a brokerage account, it's called a transfer on death designation. In a bank account, it's an in trust for designation. But if you have those kinds of designations, then your will isn't going to dispose of that asset. It's going to go automatically by operation of law to the person named on the account. The same thing applies with life insurance, annuities, and in particular, retirement accounts. So the four-legged stool, the documents that we're creating, are not the full picture. We have to make sure that you're coordinating your assets and coordinating all of the designations for beneficiaries that you have on each of those assets. So the first several pages of our questionnaire are going to ask you those questions. And it's going to cull out from you what your assets are, who the owners are, who the beneficiaries are. And then we can work them into your plan and make sure that when you sign your will, it is doing precisely what you want it to with regard to the disposition of your assets. And so looking at will planning is critical, and it's a major part of estate planning. The executor is the person who is going to be responsible for, number one, locating the will, securing it, then hiring typically a law firm to go through probate. Clients always ask, can I do this by myself? Can I go through the probate process on my own? And in New York, there are two separate probate processes. One is a small estate proceeding and the other is a full probate. And when you're looking at the probate side of this, and we want to have executors carry out our wishes, they're going to be doing it through the court under a judge's supervision. Probate in Latin means the proving of the will. And that's a process that every will has to go through. I can't tell you how many people come to me and say, well, I have a will. That means I don't need probate, right? Wrong. Every will, by definition, must go through probate. And so that's a process. We have judges, surrogates, court judges in our local counties, and we practice in many different counties in our firm, and we do estate administrations, and we do them all the time. But I can tell you that a probate administration, even though the judge is doing a great job with it, is going to take longer. It's a public process, and it's going to be more difficult. So we'll go through some of the distinctions and why you might want to consider avoiding probate, which is, of course, the topic of our seminar or webinar in 2 weeks on the 27th. But for today, what are the elements of probate? As I mentioned, every probate process is public. So you can actually go out and buy a book of published wills of Jackie Onassis, John F. Kennedy, Jimmy Stewart, John Wayne, and more modern figures, because all of their estates were part of public record, and their wills were public record. And if you want privacy, then there are alternatives we're going to talk about. Executors, if you appoint executors within the family, typically they waive compensation called executors commissions. But very often, if you name an attorney or an outside person, they will collect those commissions. You have attorney's fees because you have to have a law firm, as I mentioned earlier, to do the process of probate. That will take, in many cases, 1 to 2 years. There's a minimum time period. It's called the creditor's period, which is a 7-month time period that you have to wait before you can distribute fully from the estate. But in most cases, it takes longer than 7 months. And so something that you need to think about when you're contemplating will planning. So you can also have challenges to the will, which occur in the surrogate's court in probate. And my partner, Aaron Connor, is in court many days of the week because a lot of people have contests, will and trust, but we do those as well. So how do you avoid probate? What are some of the things to consider when you're looking at the will? What's the alternative? And the most popular alternative to a will is a revocable living trust. And a revocable trust we're going to get into today, but we're going to cover this in much more detail on the 27th, along with irrevocable trusts and the differences between the two. But the revocable trust is something that you can create today. It's a private document. It's a contract between 3 parties. The first party is the grantor, and that's you if you're putting your assets in. The next party is the trustee, and typically in a revocable trust, that's also you because you're going to set the trust up and manage it for yourself. And the third party is the beneficiary. And the beneficiary, again, in this case, is you. So you can be the grantor, trustee, beneficiary, but if you become incapacitated or upon your death, your successor trustees will step in and probate is then avoided. So you can have a private process, and people ask, well, what does probate cost? Wildly variable depending upon the circumstances and the estate. Sometimes you may pay hourly for the legal services. Sometimes the attorney will quote a fixed fee or sometimes a percentage of the estate fee. But rule of thumb for us is 2 to 3% of the estate will be the all-in costs for probate. Sometimes it's more if there's litigation. So can you avoid that? And the answer is yes. You can avoid it through trust planning. So a lot of nuances to the probate process, but taking it back to your will, it's something where you're going to want to have a comprehensive will thoroughly thought through, appointing your executor to carry out vital functions, appointing trustees to manage assets for beneficiaries after your death, and appointing a guardian if you have minor children to make sure that they're going to be taken care of and that their well-being is going to be looked after. And again, personal property, you want to, if you're going to leave specific items to specific people, you want to cover that in the will. And generally, the residue is going to be divided in amounts or percentages, typically percentages. So if you have 3 children, each gets a third, and you may want to then create trusts for those children, which can actually be done right under your will. And those are called beneficiary control trusts. And again, I'll cover those in a little more depth on the 27th. So how do you get started with a basic estate plan? Well, the questionnaire is the first place to start. And so we're going to be sending you that questionnaire for your use. It's a workbook that you can use to gather up necessary information, put down all the vital people, the people in your family who are going to be beneficiaries, the people who are going to be the executors and trustees, and you're going to have an ability to gather up all of that information. And on the back page of the questionnaire is the screen you see now, which is a checklist. And the checklist is all of the documentation that you should gather up before you have a consultation with an estate planning attorney. And so the estate planning attorney could be anyone, but we hope it's us. And so we're going to offer you, for signing up for our webinar today, a complimentary consultation. And if you look in the box on the right-hand side of your screen, if you do want to come in, and once you get your questionnaire and you have an opportunity to think about this and put down the people that you want to serve as your power of attorney, healthcare proxy, disposition of remains agent, and your executor and trustee, put together your information regarding family members as beneficiaries, who you want to benefit, how you want to benefit them, and then gather up information regarding your finances and these documents you see before you. Then you can have a complimentary consultation. Usually takes 60 to 90 minutes. And at the end of that 60 to 90 minute period, we're going to be able to put in place a plan for you that's going to satisfy your needs, take care of yourself, and take care of your beneficiaries as well. So that's been our webinar for today. I hope you enjoyed it. I hope you come see us. And we look forward to seeing you in 2 weeks on the 27th of February, protecting your hard-earned assets and creating trusts to plan for the next generation and for the rest of your lifetime. And as always, we hope you listen on Saturdays to Life Happens on WGY, Talk Radio, 810 AM, 103.1 FM. We're on at 11 AM every Saturday morning talking about life.